Welcome to Gloves Off, hosted by award-winning trial and personal injury attorney Ben Johnson, founder of Ben Johnson Law. In each episode, Ben goes toe-to-toe with guests, hashing out legal matters around the most talked-about news stories and issues. We don't pull any punches, so some language and topics may not be suitable for younger listeners.
Hey fighters, here we are. Podcast Gloves Off 32. Dishonorable Discharge. There he is. The Honorable Christopher Yates. Oh, you've been reading about him all over the press. He's like the latest and the greatest to join our firm. Judge Chris Yates, my buddy. Congratulations. How are you, buddy?
Thank you so much, brother. We've known each other for almost 50 years.
That's it. 47 this September, ladies and gentlemen. Kalamazoo College campus, 1979. Oh, my God. Isn't that incredible? And here's what's really crazy, y'all. I wouldn't say it was freshman year, even though I went to school knowing I wanted to be a lawyer. I don't remember that you knew you wanted to be a lawyer, did you?
Not at all.
Okay.
Not at all.
So I knew I wanted to get into law school, and it was such a far reach for me at that point due to my grade point average and other related issues that we won't talk about here publicly yet. Maybe another episode. But I knew that, and all of a sudden at some point I found out Judge Yates, was going to go to law school, and he did the joint MBA, Master's in Business, and JD, Juris Doctor program. So those of us went to law school for 3 years. Yatesy had so much frickin' fun that he wanted to go for another year. So he did that program and at University of Illinois. But anyway, we at one point, Yatesy, I don't know when, but we talked about you and me joining forces and doing the law gig.
You know, it's an interesting thing. This is an idea we've been kicking around for a long time, and I'm so excited that it's finally happened. I can't tell you how happy I am that I get to see you and talk to you all the time again, brother.
So I don't normally memorize my friends' resumes, but since I just introduced you a couple of weeks ago for Grand Poobah of the Year, as I call any award that we get in this day and age, in beautiful Grand Rapids Bar Association, Grand Poobah of the Year. Congratulations on that.
Thank you.
Judge Yates was, when he entered private practice, he had such a diverse, interesting background. So, Judge, tell him a little bit about before you got on the bench, because he was on the bench, y'all, for 22 years?
18 years, a little over 18 years.
But trial and Court of Appeals
Both.
together?
Yep.
Okay, I thought it was 22. I just gave you 4 more years.
I know.
All right, well, never mind then. Forget what I told him in Grand Rapids. But real quick, in terms of before the bench, okay. So what did you do? We're slogging, right? We're in the mud and we're doing the trenches. What were you doing?
I often joke that I can't hold a job because I've come through an awful lot of positions over the course of my career. I started out clerking for the chief judge of the federal court on the east side of the state. Then I clerked for a judge on the United States Court of Appeals. And then from there, I went to the U.S. Attorney's Office, worked there for 7 years as a federal prosecutor, took a break for a little over a year to work in the Clinton administration in Washington in the Office of Legal Counsel. Then in my 7th year in the U.S. Attorney's Office, Judge Paul Borman suggested that it would be a good idea.
Which was my criminal judge in United States versus Feiger and Johnson, for those of you playing at home.
He told me at lunch one day that he thought it'd be a good idea for me to move over to the west side of the state and run the federal public defender's office. And
very kind of Judge Borman. Why did he just fucking quit the bench and go over there himself and do it? But no, he gets Yatesy to do it. And you did it, dude.
5 weeks after that conversation took place, I found myself in Grand Rapids talking to the judges for the first time. It was an office that didn't get off to a great start. It was my job to try to clean it up. And 7 years later, I'd had enough of being a federal public defender, left there, went into private practice, worked at a couple firms, and I was a named partner in both of them, small firms. And then in the midst of all that, I got appointed to the Kent County Circuit Court, the trial court.
Grand Rapids.
And by the time I got there, the only thing that was left for me was the worst docket, which was half family, half criminal civil. And almost immediately, 5 days after I was sworn in, somebody filed to run against me. So my first
remember that.
My first 7 months.
You had up for re-election.
Yeah, I had to run a contested campaign and learn family law and learn civil law and learn criminal law and how to handle it as a judge. I mean, I'd done those things before, but not family law. And so I stayed there for on that docket for about 4 years. Then they asked me to run what's called a complex business docket. Did that for 10 years, all civil, all
So is this
large
businesses basically suing businesses? So.
Yep, right. All civil practice, nothing else, same people over and over again in front of me. And after I'd been on the circuit bench for 14 years, Governor Whitmer put me on the Court of Appeals with great help from my dear friend. I was chosen, and I sat on the Michigan Court of Appeals for a little over 4 years. It was last December that I went to the Governor's Council and explained that I was ready for a career change. And
I read retirement. It's like, he's not retiring. He's coming to work for a frickin' law firm. Quite the opposite. Why'd you sell that bag of goods, Judge? Hence, dishonorable discharge.
Right. It was a strange thing because I'd just been reelected to a 6-year term, so I had 5 years left to serve on my term. And so it was considered just completely illogical to leave the court at that point because I didn't have to worry about anything except just doing my job for the next 5 years. But a couple of things happened that changed my life and changed my mind about everything. The first is that one of my daughters, Courtney, had been working for Ven's firm for more than a decade. But I had...
Which is weird because she's only like 13, 14 now. I don't know that. If you guys saw Courtney, you'd saw she's a beautiful soul, always a smile on her face, and she works her tail off. And she started at our Grand Rapids office when we first opened it back in 1904. So Yatesy had to be early 2013.
Yeah, that sounds right to me.
And Court came, and we'll get Court on this because they would love to see and hear Courtney. She's amazing. But, yep, Courtney started 2013 when we opened that office, Judge.
And so the first big development that made it so attractive to join the firm was that Ven decided, and he announced it without telling Courtney first one day at the Nationals at Kalamazoo College, that Ven Johnson Law was opening a Kalamazoo office and Courtney Tucker was going to run it.
What? Like she was going to vote no?
She embraced that, and she became the one and only in the Kalamazoo office. So as luck would have it, I have twin daughters, and one of them was going to Western Michigan University.
Go Broncos.
And Courtney was always busy with major cases in Detroit, and so somebody needed to keep an eye on the office when she was gone. And I don't know whether it was Ven's idea or Courtney's idea.
Mine, like all good ideas.
And so he offered one of my twins, Natalie, a part-time job at Ven Johnson Law, where she still works today. So at that point, the office was Courtney, my oldest, Natalie, one of my youngest, and nobody else. And so at that point, Ven told me, if you go to Kalamazoo, we can fill out the office that way.
There you go.
And
there was a plan to begin with, ladies and gentlemen.
I can't even tell you how enticing it was to go work for truly one of my best friends in the entire world in an office with two of my daughters. And this is really, and I mean this sincerely, a dream come true. And I can't thank you enough for this opportunity.
Or we'd say, yes, Yatesy, yes. So, no, that was a beautiful tale, and happens to most of it to be true, which really makes it really good listening, we hope. So, all right, so here's the deal. You've been a judge for actually longer than you've been a lawyer.
Yeah, I was a lawyer for, I'm trying to add the years.
Yeah, do the years, Judge.
Yeah, it's 20 years in practice, but 3 years as a law clerk before I actually started practicing in court.
So here's what you need to know about law clerks. When you are tops in your class in law school, you really do one of two things. A, you go work for what I call mega firms, or we call big law. Right. So Dyke, Gossett, Miller, Canfield, Dickinson, Wright, all sorts of other firms in the Detroit metropolitan area, and you get paid the huge buck. Wasn't me.
Wasn't me.
Wasn't me. The other thing you do, which Yatesy could have done, is you go work for a judge. And in Yatesy's case, he was hired by a federal judge. Judge Churchill was up in beautiful Bay City, Michigan. Mom and Dad were still, my daughter Aries in here, Grandma and Grandpa were still in the Saginaw house, so they got to see Yatesy every once in a while. But he was working downtown Bay City with 3 other people.
And this is a great...
I don't mean in the courthouse. I mean in downtown Bay City with literally 3 other people.
And this is a great little story, too, because my wife and I moved to Bay City. We actually went to Essexville,
Essexville
which is
Garber
a
High School
suburb of Bay
fell
City.
victims to the mighty generals of Douglas MacArthur in tennis.
And we signed a lease for an apartment, and the lease didn't start till the 1st of September. And so I had about a week in August where I couldn't get into the apartment yet. And we stayed with Ven's parents.
Oh, Vernon Donna. You were
Saginaw.
4595 Wall Street, Saginaw, Michigan, 48603. There's a country western song. Look it up, Saginaw, Michigan.
Yep. They put up with us for a week. My wife and I moved in with them.
Are you kidding me? They were like they were. My mother would say they were tickled pink.
Yeah,
that's really cute. I'd forgotten that. So all right, so Yatesy, you're on the bench. You have all this trial experience, trial judge experience, and then you go to the appellate court. And for those of you, you got to listen to an episode. We're going to do an update coming up soon with Chris Desmond, our appellate director extraordinaire. And as he explains, trial court is where we do the majority of our stuff. And then when we win, or lose sometimes, but when we win and they want to appeal it or they want to delay paying it, they appeal it to a court of appeals. And that's in state and federal court. That's what that's called. And Yatesy was on the state court. So he was one step below the Michigan Supreme Court. Here's my question. First of all, what were you thinking about leaving the bench? And secondly, what do you think in terms of overplay? How is that going to help you be a better lawyer for VJL clients now?
Well, first of all, the decision to leave the bench is really uncommon. Most people who get the opportunity to be a judge never give it up. I mean, they retire off the bench, and that's the end of it. For me, I've always, through my career, looked for new challenges, and I felt like I had learned a great deal on the Court of Appeals, but I felt like I had reached the point where I understood everything that was happening, and I was ready to do something different. I mean, the life of a judge on the Court of Appeals is really isolating. If you're a trial court judge, you're seeing people, lawyers, clients, criminal defendants, all day, every day. That's what you do.
You're interacting with them because you have literally hundreds and thousands of cases.
Right. On the Court of Appeals, they only let us out in the wild for 2 days out of every month. We sit for oral arguments on a Tuesday and Wednesday in the first half of the month. And other than that, I was spending all my time in my office, and there was only one other judge on the floor with me. She's a dear friend of mine, but and every day was like every other day. Now, I did have the opportunity to sit on the Court of Claims for 2.5 years.
Which is kind of a trial court aspect.
Right.
We'll talk about in one of our upcoming cases being a really important case that you all hear about called GOSS, G-O-S-S. But in any event, so you're kind of getting back to your trial roots, but at the same time, because we have an appellate department, and Chris and then Tom Carr, who you met, you're going to be able to work on some of that stuff as well.
Yes. It's an interesting thing because everyone seems to innately understand what a trial judge does, but nobody has any idea what an appellate judge does. As a matter of fact, my brother was so terrible at explaining to people what my new job entailed.
Stevie?
Yeah, that I sent him a link to one of the oral argument sessions where I'd been the presiding judge, and I told him, would you just watch 20 minutes of this so you can understand what I do? On the Court of Appeals, I joke about this. You really don't have any power individually because everything's done in groups of three.
Right.
And you have to get an agreement to issue an order. And as a result of that, I spent an awful lot of time talking and working with my 24 colleagues on the Court of Appeals.
Right. Well, in essence, your job was to read and to write.
That's exactly right.
Which I don't mind those aspects, but they're probably my least favorite of all stuff that we do as lawyers. But to tell you the truth, I actually do enjoy it more than I would normally let on. But
you're much better on the law than you like to admit.
Well, that depends on who you ask and what day it is, right? But what I think is interesting, so folks, we have a few cases. We call them our whippet cases. We've already gotten some considerable press on one of them, but sadly, what we see across the country, let alone here in Michigan, are folks that are buying these nitrous oxide, is that what they're called?
Yeah, nitrous oxide canisters.
They get these canisters, right? And they're only legal to be sold to people that use them for culinary purposes, kitchen. So you're going to use it because you ran out of it in your whipped cream, which is complete bullshit. So what you now have is stores, gas stations, smoke shops, and other people selling paraphernalia and other related drugs you have folks selling them to that aspect of folks who, let's just be honest, Yatesy, they have no fucking idea about using it in the kitchen.
Yeah, I think that's exactly right. Ordinarily, if you were to properly use nitrous oxide, there would necessarily have to be hoses connected to something where you're injecting nitrous oxide into whatever the item is you're cooking. Right. Whipped cream's a good example of it.
Right.
But the idea that anybody would ever just simply take nitrous oxide by inhaling it out of a canister is so far afield from what it's supposed to be sold to do.
So Whippets, huffing, is that huffing?
Huffing.
Is that, some people call it huffing, I believe, as well?
Yep.
And I know, I also had a case years ago at Cole Seacrest, believe it or not, that long ago, where they were huffing stuff, something out of some type of a Johnson & Johnson can. I forgot what but they put a rag over top and squirted it and then sucked it in their mouth. And it was a similar type high to what's going on with Whippets. So here's the thing, ladies and gentlemen. Think about this. You are now selling this to people that you absolutely know, but you pretend not to, are going to be using it to get high. And then they buy it from your store, and they do it while they're driving. Let me repeat that. They are doing Whippets while they're driving. Yatesy, tell them about the high with Whippets.
Yeah, the difficulty...
Not that you would know from firsthand experience at Kalamazoo College.
Absolutely. One use of nitrous oxide that you'll see is in a dental office where they want to actually put you under so they can perform dental surgery without you knowing what's going on or feeling the pain. Now, if it's that powerful and it has that effect and it knocks you out to the point that you don't know what's going on, you just have this sense of euphoria. Now just imagine doing that when you're
Is that
driving.
why I get that every time I go in and have any type of exam, even if it's for flossing?
No.
But to be fair, that is legal. You can use it for that. It is a pain control situation.
Right.
But these guys that are taking this stuff and squirting in their mouth or putting it in a balloon and so forth, Yatesy, they ain't getting that kind of high. What are they getting?
Right. I mean, if you were to ask a dentist who routinely uses nitrous oxide as essentially a manner of dulling pain and allowing patients to get through it, what the dentist thinks about somebody doing that while they're sitting in a moving motor vehicle, the dentist would be absolutely appalled to think that anyone would ever do something like that, because the use of nitrous oxide is almost by definition truly disorienting.
Right. Right.
And when you're disorienting yourself in that way, the last thing you want to do is be driving 70 miles an hour down a highway.
Yep. So in our particular case, and remind us the name of the case, Yatesy, this is in Livingston County Circuit Court.
Yep. There's one case called Halford and another one called Genghis. One's in Macomb, one is in Livingston.
So in the sad, I'll call it consistency, if you will, between these cases is you got dumbass A and dumbass B who are doing Whippets while they drive. And in the Halford case, that person huffed and got so high he passed out. And those of you that are familiar with I-96 in Michigan, that's from Detroit to Lansing, Grand Rapids, etc., they were somewhere between Detroit and Lansing. He was going, dude was going, I think, westbound. Not Halford, Jessica's dad was coming eastbound on 96. There is a huge grassy median between the two. You couldn't miss this if you tried. I mean, literally, this is probably, Yatesy, 200 yards or more of grass in between the two. You go down an embankment, you got the grass down, and then you come back up. And this dude did all that and slammed into, I forgot Jessica's dad.
Yeah. Yeah.
And so hit him head on.
Yep.
Huffing dude died, and then Grandpa, as I call him, Jessica's dad, died as well. And what's the other case that I just met those really nice folks?
Oh, the other case is called Genghis. That's the one out of Macomb.
And what happened there?
Same sort of thing. I mean, in each one of these instances, you have the deceased, but our client, for all practical purposes in each one of the cases, was just driving completely as the law requires under perfectly fine conditions and was essentially just run into by somebody who was huffing nitrous. I mean,
and that dude lived.
In the other one, in the
Yeah.
Macomb County case, yeah, he's been prosecuted.
That kid, and he's in jail, and
Yes.
he actually, to his credit, admitted that he was doing whippets behind the wheel. The other case, the Halford case, that dude died, and they found him. The investigating officers found him and documented with photos, thank God, that he had the whippet can in between his legs. There is some type of a mouthpiece type thing, Yatesy, that they use. I've forgotten what it was, and that was on the floorboard in front of this dude. Where he obviously had hit the steering wheel and dashboard and God knows what else. So in the criminal investigation, which wasn't all that detailed because that dude died, but they still did a nice job and looked at what happened. Then they said, okay, this dude died because of huffing, and now we're suing these people. And what do they want to claim? Oh, you don't know he's huffing because there's no blood test that shows it. And so the shit that these people come up with, Yatesy, is unbelievable. Yatesy just handled a motion on that case where the defense lawyers were trying to throw that case out of court, claiming that we couldn't prove that he actually did a whippet because the blood test that they run, there's only one blood test that they can run that even shows anything, and that's sometimes it does and sometimes it doesn't. And these folks didn't run it because, of course, the guy's dead, and it was just a kind of, quote, routine investigation at the time because there's no criminal prosecution because the dude that does is dead. And now these guys that we're suing are trying to run this crap that we can't prove it. And then enter Judge Christopher P. Yates into that courtroom. Come on, Yatesy, this had to feel good when you were in there arguing in that motion on behalf of an innocent victim like our client.
I have to say, it's like anything else that you don't do for a long time. I mean, for 20 years, I was on my feet all the time, trying cases to juries, arguing motions, arguing appeals. And then I stopped when I became a judge, obviously.
Right.
So for 18 years, I had not been an advocate in court. So this was the first time in 18 years that I was on my feet advocating on behalf of a client. And I thought it was going to feel really awkward, but not at all. Apparently,
You dove in.
Apparently, arguing motions is like riding a bike. You never forget how to do it. And I have to say that everybody was very kind to me. It's an odd thing going back and doing something after such a long time away from it. And I felt thoroughly comfortable. And had I not felt thoroughly comfortable, I might have been second-guessing my decision to go back into practicing law because I might be over the hill by now. But it turns out I'm not.
So in our major cases, folks, that we have, in almost every single one in this day and age, the defense at some point files a motion to throw the case out of court. We in Michigan call it a motion for summary disposition if it's under Michigan law. If it's under federal law, it's called a motion for summary judgment. Translation is, okay, here's judge, this is what the defendant's file. Here's what we say happened here, and here's how plaintiff, us, cannot ever hold us legally responsible in a court of law for all these reasons. And, of course, what we do is we respond to that, and that's Chris Desmond, Tom Carr, and now Judge Yates will be on that team as well. And then we go argue that, we hope, in court, and that's what Yatesy did. And the outcome?
We prevailed.
Yay.
And the case goes forward. I mean, at the end of the day, we're not asking for anything special. We just want an opportunity to tell a jury about what happened and let
we want our client's day in court.
Right.
A right to a jury trial. And what's really weird for those folks out there, we kind of take those words for granted. It doesn't happen a lot, y'all. And especially in civil cases, the amount of, especially if there's a major injuries or a death or both, the hurdles that we have to jump through, you wouldn't even begin to believe me, because we have to win this. And I call it mini trials. That was a mini trial.
Yep.
You had to show proof to the judge that we do have, we call it genuine issues of material fact. That's all lawyer bullshit for. There's a real dispute here. We say that, they say what they say, and this is something that only a jury. Jury is a finder of the fact. Judge rules on the law, and then gives that to the jury. The jury listens to the facts, and then they decide what really happened. And that's where how we won that when the judge said there are genuine issues of material fact here for a jury. This case is now headed to trial.
Yeah, and I think it's worth noting, and I spent so many years on the trial bench, that motions for summary disposition are virtually never filed by plaintiffs. Plaintiffs usually take the position, all we want is to put the case in front of a jury and let members of the community decide it.
Yep, true. I can tell you, I can't think of the last one, and I've got cases that are so obvious that we are probably entitled to that. I don't want to do that. And half the time it's because, what we all know as a trial lawyer, I want to put that bad stuff in evidence.
Right.
The jury needs to hear it. And because the same jury that listens to their bullshit on who's at fault, they're the ones that decide my client's damages and how much to award. I want that same jury to make that determination. That's something that is usually works in our favor, for our client's favor. So that's exactly what I want to do.
And if I may interview you for just a moment and ask a question, you had a case just like this that resulted in an enormous verdict where they didn't concede liability until the very end of the trial. And you could have moved for summary disposition before the trial even started, but you chose to try the entire case to the jury, and it turned out obviously extraordinarily well.
We wouldn't have won that. We would not have won that motion if you're talking about Novak. We would not have won that before trial. After trial, had they waited until the proofs had all closed, I could have gotten a DV. I agree. It's called a directed verdict, and that's the judge would have ruled that this guy was negligent.
Right.
But because of all the things that happened during the middle of trial.
Right.
So my deal is, I wanted the jury to see all that. And even though one of our Court of Appeals judges didn't like me commenting on that, that's what trial lawyers do, Judge Reardon. When something happens bad in front of a jury and and one side or the other misbehaves, the jury gets to take all of that into consideration. And it's not just something that's good for me, therefore I can't use it. So I'm glad that Judge O'Brien, thank you, and Judge Young, thank you. 2-1 opinion. We had a great victory in Novak. And when I'm calling out, I'm not calling anything out. It's the facts. And Judge Reardon's a great judge. He's been on the bench forever. He's one of your compadres. He's certainly entitled to his opinion, but lucky for us, and more importantly, our client, the other 2 judges went our way. So we're certainly proud of that.
Yeah, and if I can just come back around to that too, one of the interesting dynamics on the Court of Appeals is that because you have 3 judges on a panel, you don't have to get 3 votes to prevail on appeal.
We always say first 1 to 2.
Right. Although I will say that in my experience on the Court of Appeals, I worked very hard to try to get 3 of us on every single opinion that I wrote. To me, there's real value in appellate courts speaking in that manner.
Interesting.
In the long history of the United States Supreme Court, most of the truly significant decisions have come down 9-0 because the Chief Justice understood it. Think Brown versus Board of Education.
Right.
It was so important for that to be 9-0.
They were sending a message, no more discrimination, allegedly.
Right.
Until we just redescribe discrimination now in our world, but don't get me on that.
Right.
topic.
The Supreme Court's order that President Nixon had to turn over the tapes, 9-0.
Right. Oh, that's a good point. Really good point.
So I've been a big believer in trying to get to unanimity if you can.
All right. So you've only been doing it for what, 3 weeks, month, something like that. What's been the most difficult transition so far?
You know, the interesting thing about moving back into private practice is to realize that I'm the one who has to keep everything going. When you're a judge, particularly on the Court of Appeals, everything comes to you.
That's interesting.
And so when I would get a case assigned to me, it had been worked up by our research division, and then I had a law clerk who would work on a draft. And I mean, I'm notorious for completely rewriting everything that came to me, so it would be my opinion in the end. But I mean, it's a much simpler process. In the trial court, not only do we have to drive the discussion, but there's plenty of room for thinking things through and creativity. And I'm getting used to that now, that there's much more opportunity to try to work around problems rather than just to run headlong into a wall of precedent.
That's interesting. That's interesting. I have no idea what you just said. Zero. None. But you know what? Ladies and gentlemen, here's what's good. Yatesy has been dumbing it down for me for 46.9 years. And so when we're done with this, he'll do that one more time.
I will say this. Ben just finished a trial, and I enjoyed the fact that he called me at 10 o'clock one night to talk about stuff. I was driving to argue a motion when I got something from Anthony asking for to answer a question of law.
Hey, when you need to know, you need to know.
That is really fun. I pulled over to get gas at exit 77 and did some quick research on my phone.
Remembers the exit number.
Only sent an answer. I mean, but that really is so exhilarating to feel like I'm part of a team now.
Well, there's no question you are. You're an invaluable member of the team. And Yatesy's in our Grand Rapids office, although we obviously here in Detroit today.
Kalamazoo, but yes.
What did I say?
Grand Rapids.
No, I didn't. Oh, my God. That was Freudian. We were in GR,
I've been driving to the wrong place.
Yes, you have. We were in GR from 2013 until 2020. There was this thing called COVID. Welcome back, everybody. And then when the time to re-up the lease, they wanted to run some shit on me about they wanted me to give a 10-year deal instead of a 7-year agreement, and they wanted to up the price. And it was like, there were a few choice words, and the second one was you. So, there ended Grand Rapids, and I knew it was a matter. I wanted to do Kalamazoo from the beginning, but Tom Gross, Tom Gross, I'm throwing that name out too because it's true. Tommy said we should be in GR, and you know what they say when you make a mistake in life? There are no mistakes. There's only learning opportunities. So we're going to go with that, and it was not a mistake at all. I enjoyed my time in Grand Rapids. I had a condo downtown. I loved hanging out there. Yatesy, I'd come see you and Court and whoever and folks that were working in our Grand Rapids office. Really enjoyed that. But I always knew Kalamazoo. Kalamazoo's a special place for me. You're going to hear a lot more about that. You already have in past stuff. That's where I went to college, and that was really my first safe zone is what I'm going to refer to it right now, and we'll just leave it right there. And I had the incredible luck of meeting Judge Yates, Mark Riley, a coach at K, and Mike Asher, who's a buddy of ours that I just came over to the house. I hadn't seen him in months, and so Ash, we call him Slash. Slash came over with his lady, Kimmy. Hey, shout out, Kimmy. And I don't know how much luckier a guy can get than meeting what I refer to as my three brothers. And they've been in my life. You know, we all ebb, we flow, right? Marriages, divorces, kids, right. Tragedies, sickness, illness, parental stuff, and everything. And yet we're still there. And when you call, I pick up. When I call, you pick up, except for the time when I called you and you didn't return my phone message until I finally threatened you. That was back in the day, bro. That was back in the day when we still had voicemail messages. What were they called? Not voice. What were they called back then?
Yeah,
it was telephone message.
Yeah, right.
Answering machine.
Answering machines.
It was an answering machine, y'all, and he wouldn't frickin' pick. I knew he was in a bad spot. So finally I gave him one of these, like, will you fucking call me? You're going to, like, hide from me. I know what you're going through, and blah, 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 blah. And guess what? It worked. Back from the dead. Ladies and gentlemen, Christopher P. Yates.
I do have to say one more thing about Kalamazoo, because the seeds of my move to the Kalamazoo office were planted months before I told anybody that I was making the decision to join Venn Johnson Law. We were at the Nationals, and they play at Stowe Stadium on the campus of Kalamazoo College.
This is tennis, that whole big tennis tournament that we sponsor.
In my view, the best tennis facility in the entire country. It means so much to me. And we were sitting there watching a match, and I knew that he'd opened the Kalamazoo office. I knew there was nobody there. And I remember I put my hand on his shoulder and I said, I think I'd probably like to join you in Kalamazoo if you would be interested. And he looks at me and his eyes are really big.
I can only imagine what I said.
Really? And that's when the conversation started. It was actually that August at the National Juniors, and December was when I finally made the decision.
I don't remember. All I know is this. I told you, don't come to me unless you're really ready and want to, and I don't want to hear about, I need to think about shit. So just don't tell me. Just tell me after you leave, and then we would have real discussions, and that's exactly how it went. So for those of you that know, I can't believe you and Judge Yates had any, we didn't have shit. It was, because you know what? I've learned a lot in this profession and life in general, but this profession in particular. But what Donna Johnson, Saginaw, Michigan would say, I'll believe it when I see the whites of their eyes. So I hope that's an appropriate comment in this day and age. I think my daughter's giving me the okay, so that means probably. All right. So Yatesy, you get the absolute pleasure, honor, and privilege of signing us off. So what the hell do you have to say for yourself, Dishonorable Discharge?
There are many times when you have to make a decision in your career, and you hesitate and you think and you try to figure out how it's going to go, and you have this trepidation, and you never know how you're going to feel when you get there. And I confess, I had these thoughts before I came over. I mean, I knew this is what I wanted to do, but I didn't know how it would feel to leave the bench and go back into practice. And over the last 4 weeks and 1 day, 2 days now that I've been with the firm, I can't remember any time I've made a job change where I felt more comfortable with my decision. I mean, seeing you all the time, seeing Court, seeing Natalie, and just getting back into the work, getting back into the arena, as I told you, has been just exhilarating and rewarding, and I'm just so happy to be here.
All right, so y'all know the title was complete bullshit, right? Dishonorable District. Yatesy has never done anything dishonorable in his life. So that's why I used it, because we're going to plug it that way with this picture everywhere, and all of a sudden people are out there going to go, wait a minute, Johnson's going to put all the dirt out there on Judge Yates. Guess what, y'all? Psych! Not happening. I'll see you guys soon. Wait till you hear the upcoming episodes. They're unbelievable. Area right now is over there typing all of the, what do we call them, lines? What do we call those? Huh? No. When you're actually writing stuff that you claim that I'm going to say.
Oh, the script.
The script. Guess what? You all know better than that shit. It ain't happening. So, all right. Love you guys. Go Fighters. Judge Yates, you the man,
brother.
Baby. Welcome back to the good side of the V, baby.
I'm so glad to be with you, my brother.
Signing off. See you, Fighters.